Well, good evening, everyone. I'm proposing to speak about issues relating to forfeiture of leases and waiver in particular, which arose in a case before Mrs. Justice Kellen Bacon in the High Court earlier this year, and that is the case of the Tropical Zoo Ltd and the Mayor and Burgesses of the London Borough of Hounslow. So, by way of introduction, some background on forfeiture. Forfeiture is an ancient remedy, the right to re-enter property. It is truly the landlord's nuclear option because it determines the tenancy on the basis of a breach by the tenant or the occurrence of a specified event such as insolvency. And the result is that it will end both the lease and any derivative interests. The draconian nature of the remedy has meant that a host of restrictions and rules has grown up over time, and both under common law and more recently statute. It is said that the law leans against forfeiture. The Law Commission has produced 2 reports and draft bills recommending reform of the law of forfeiture in the last 30 years, but to no avail. They've described the law as both complex and incoherent, and I suspect most lawyers would agree, and hence my reference to the forfeiture jungle in the title. I decided, therefore, that it would be quite useful to consider aspects of the law of forfeiture through the lens of this recent case. So one of the restrictions on forfeiture is the common law doctrine of waiver, and I put on the slide the comments of Mr. Justice Sachs, as he then was, in relation to waiver, and he uses the metaphor of a minefield in relation to the technicalities which arise. When a right to forfeit arises, the landlord has the option either to act on it and terminate the lease, or alternatively to treat it as continuing. He is put to his election. If he determines that he will treat the lease as continuing, then the right to forfeit is lost. It is waived. There are 3 elements to waiver, and the classic statement derives from my namesake case of Matthews and Smallwood, which I always like to mention if I can, although I don't believe that the defendant was actually a relative. And then more recently, a more up-to-date statement in Cornilly and Saha in the 1990s. So the first element is knowledge by the landlord of the circumstances giving rise to the right to forfeit. And that knowledge can be either express or constructive or imputed. And it's knowledge of the basic facts giving rise to the right to forfeit. So knowledge of the legal ramifications is irrelevant. Secondly, there must be unequivocal recognition of the continued existence of the lease by the landlord. And in Expert Clothing Service Sales Limited and Hillgate House Limited, it was said that this means conduct so unequivocal that when considered objectively, it could only be regarded as having been done consistently with the continued existence of a tenancy. So the objective assessment is carried out in the light of all the circumstances, and that means that the landlord's motives or intention for the conduct are irrelevant. And likewise, so are the tenant's understanding of the legal consequences. In Central Estates Belgravia and Woolgar number 2, for example, a clerk mistakenly demanded and accepted rent, but that was held to be a waiver. In other words, if there is scope for some other interpretation of the landlord's conduct, then the consequence of waiver can be avoided. And the final element of waiver is communication of the recognition of the continued existence of the lease to the tenant. So acceptance of rent has had a special status in the law of waiver since Tudor times. Acceptance of rent falling due after the landlord has knowledge of the breach has been considered to waive the right to forfeit. On a practical level, in relation to checks, it is of course difficult for a tenant to argue that rent has been accepted if a cheque has not been banked, and thus the advice always is don't accept a cheque, return it. But if it is banked accidentally, then processing it is not conclusive of the payment being accepted as rent. And that is derived from the Sea Hive investment case, where the tenant sent a £10,000 payment, which was partly in respect of a bankruptcy debt and partly in respect of rent arrears. The landlord banked the cheque, but then returned an amount equal to the rent arrears. And the Court of Appeal said that the processing of the cheque was evidence of the payment, but for waiver, it had to be shown that the payment was accepted as rent by the landlord. With regard to automated payments, because it is acceptance, not payment, that is the waiver, if rent is received electronically, then there will be no waiver, provided that it is returned as soon as reasonably practical. And that was what happened in the John Lewis Properties case, which related to the Peter Jones department store in Sloane Square. Finally, I should mention the distinction between once and for all and continuing breaches in the context of forfeiture. If there is a continuing breach, such as, for example, disrepair, then a new cause for forfeiture will arise every day, and therefore a waiver of the right to forfeit by the landlord today doesn't prevent the landlord from exercising the right to forfeit tomorrow. By contrast, if it is a once and for all breach, such as the payment of rent or, for example, an unlawful subletting, then if the landlord waives the breach, it is lost forever and he is left only with his remedy in debt or damages. So bearing all that in mind, let's move on to the facts of the Tropical Zoo Ltd and the London Borough of Hounslow. So this case relates to a 125-year lease of 25 acres of land, which was granted to the tenant in 2012 for use as a centre for education, conservation and leisure, including a tropical zoo visitor attraction with associated facilities. The tenant, the judgment says, has a collection of 489 vertebrates and 73 invertebrates. And from the beginning of the lease, the tenant operated Hounslow Urban Farm on the site. Now, the site is very close to Heathrow Airport, which might not be thought to be an ideal location for a visitor attraction. However, this is not necessarily a drawback, because I found a review of the farm online which states a further attraction is the planes, which are so close to landing at Heathrow that you can read all the writing on them. Anyway, on to the relevant covenants in the lease made by the tenant. There was a covenant to observe and perform the tenant's covenants as defined. And in a schedule to the lease which set out the covenants, one of those was something I'm going to call the covenant to remedy, which was to remedy any breach of a tenant covenant notified by the landlord to the tenant as soon as possible, and in any event within 2 months of service of the notice. There was also a covenant to complete construction of the zoo building within 2 years, and I'm calling that the construction covenant. Now, in relation to both of those two covenants, if they were breached, the lease contained step-in rights for the landlord to go onto the land and remedy the breach and recover the costs, so rather similar to a Jervis and Harris type format in relation to disrepair. And finally, there was, of course, a proviso for re-entry for breach of the tenant covenants. And I've set out the words of it because the phrase in parenthesis was important for purposes of one of the arguments made by the London Borough of Hounslow. So a right to forfeit if at any time there is any material breach of the tenant covenants, the landlord may, even if the landlord has previously waived any previous right of re-entry, re-enter the premises. So what happened? Well, essentially, the tenant was unable to get funding for the zoo building. So by March 2014, there was no zoo building, and in fact, construction hadn't started at all. Time passed, the tenant attempted to gain funding by other means, but none of his proposals got off the ground. So ultimately, in November 2020, Hounslow served a notice under the covenant to remedy in relation to breach of the covenant to construct the zoo building, and required the remedying of it within 2 months. Then when that period had expired in February of 2021, Hounslow served a Section 146 notice, and that relied on breach of the covenant to remedy, and also instructed its agent not to demand or accept rent. So no further rent demands were made. The tenant carried on tendering rent, but the payments were returned promptly on all but 2 occasions, and those 2 occasions led to one of the arguments relating to waiver. The tenant thereafter sought a declaration, and this was the stuff of these proceedings, that it was not in breach of covenant, and alternatively that the Section 146 notice was invalid due to the acceptance of rent when the delayed payments were returned. And so the scene was set. So what were the issues? Well, firstly, was the covenant to remedy a freestanding covenant for breach of which the right of re-entry was triggered? Secondly, did the landlord waive the right to forfeit? There were 2 limbs to that argument. Firstly, did the forfeiture clause as drafted exclude the doctrine of waiver? And secondly, if no, did the delays in returning the rent payments amount to waiver in relation to the breach of the covenant to remedy? Thirdly, there was an argument as to whether acceptance of rent during the currency of the Section 146 notice should not be treated as waiver in any event. And finally, excuse me, should the court grant relief from forfeiture? So firstly, was the covenant to remedy freestanding? The parties agreed that the breach of the covenant to construct the zoo building was a once and for all breach, and that the London Borough of Hounslow had continued to accept rent after that breach, and that therefore it had waived the right to forfeit in respect of that breach. So the landlord's case was that the failure to comply with the notice to remedy was a separate freestanding covenant, just like any other covenant in the lease, which in itself allowed the right to forfeit. On the other hand, the tenant was arguing that the clause was simply a precondition to the landlord's step-in rights under the Jervis and Harris type format. Mrs. Justice Bacon went through the exercise of construing the clause, and she set out the approach of Lord Hodge in the Wood and Capital Insurance Services, which refers to the principles in both the Rainy Sky and Arnold and Britton cases. She concluded that it was a freestanding covenant. She said it was perfectly unambiguous, the way that the clause had been drafted, and that was by reference to the ordinary meaning of the words and the contractual and commercial context. So the effect of the clause is to give the landlord another chance to forfeit. He can effectively revive the right to forfeit by serving a notice under the covenant to remedy in respect of the previous breach which had been waived. The second issue, the first part of that, had the parties contracted out of the law of waiver. The London Borough of Hounslow were arguing that the parenthesis that I've referred to, even if the landlord has previously waived any previous right of re-entry, had the effect that the parties had ousted the common law of waiver. The tenant, of course, argued that this was an incorrect construction, but also that a clause which purported to oust the doctrine of waiver could not have any effect as a matter of law. Again, Mrs. Justice Bacon went through the construction exercise, and she decided that the clause as drafted did not exclude the doctrine of waiver, and that basically all it did was to confirm that a waiver in respect of an earlier right of re-entry will not prevent a later forfeiture in relation to another breach of covenant by the tenant. Therefore, it wasn't necessary for her to determine whether the parties can contract out, which is slightly disappointing, really, because it would have been good if we'd had a decision on that. But she said that she didn't consider that the authorities that had been cited established such a broad and general proposition, and that the authorities that the Tropical Zoo had relied upon were decisions on the particular facts of the cases. So she definitely emphasised that one must consider the specific words of the term concerned, and she wasn't prepared to reach an abstract conclusion. The second element of the waiver argument, whether the acceptance of the rent payments by the agent had been a waiver. And in relation to this, she looked at the role of the landlord's agent. She referred to an early Victorian case, Nash and Birch, in relation to the scope of an agent's authority, where the authority to receive rent was considered in relation to instead the authority to grant a lease. And it was held that if there was only authority to receive rent, then there wasn't a waiver. The Tropical Zoo argued that this authority had been overtaken by the Woolgar case that I referred to earlier, the mistaken acceptance of a payment due to a clerical error. But the judge said that that case was distinguishable because the agents in Woolgar had full authority to manage the landlord's properties. And likewise, the John Lewis case that I mentioned earlier was raised, but there the payments were made to the bankers who again had no authority to make business decisions on behalf of the Cadogan estate. The salient passage in the judgment is at paragraph 115. A landlord will not, however, be regarded as having accepted rent and thereby waiving the right to forfeit solely on the ground that a payment has been accepted by the landlord's bank or other agent, where the agent has the authority to demand and or collect rent, but does not have any wider authority to make decisions on behalf of the landlord. So not enough simply to have the authority to receive the money for there to be a waiver of forfeiture. So then the judge considered, had waiver occurred here? No, because the landlord's agent performed a treasury function, not a management function. And therefore, the failure immediately to return the rent on 2 occasions did not in itself establish acceptance by the landlord. But then the judge considered, could London Borough of Hounslow nonetheless be regarded as having accepted the payments by virtue of the delay that occurred before they were returned? Was there such a delay as might reasonably cause the belief in the tenant that the payment had been accepted? The Tropical Zoo said that the delay entitled them to believe that the rent had been accepted and that there was therefore a waiver. Mrs. Justice Bacon said that the court has to carry out an objective assessment of the landlord's conduct and the effect that it might reasonably have produced on the tenant. And on the facts here, she considered that there was no scope for an inference of acceptance of the payments. In one case, there had been an 8-month delay, but that had been because the payment had been returned to the wrong account. And in the second case, which was a 2-month delay, at that stage, the defence had already been filed by the London Borough of Hounslow stating that they intended to forfeit the lease. And the judge therefore felt that it was fanciful effectively for the tenant to suggest that in those circumstances there could be an acceptance of the payment. So the conclusion was no waiver of forfeiture. The next point was whether acceptance of rent during the currency of Section 146 should not be treated as a waiver. This, I think, is a rather bold argument to have been made by the London Borough of Hounslow, and indeed counsel for London Borough of Hounslow had to rely on a New Zealand Court of Appeal authority. This related to service of a notice equivalent to a Section 146 notice in that jurisdiction. And the court there in New Zealand said that the acceptance of rent pending expiry of a notice could not be regarded as an election not to forfeit because the landlord can't elect to forfeit until there is an unconditional right to do so. And during the time when a notice is prepared and then served, it can't be said that there is a completed right to forfeit. It's only when that period has expired and the tenant hasn't complied by remedying the breach. Well, the judge gave that argument very short shrift. She said that isn't the law in our jurisdiction, and it is well established that acceptance of rent is an unequivocal act amounting to waiver. Finally, the judge had to consider whether relief should be granted. And here, the jurisdiction for relief derives from section 146(2) of the Law of Property Act, which basically gives the court a very wide jurisdiction to grant relief on such terms as it thinks fit, including as to payment of costs, damages, compensation, penalty, and even to grant an injunction to restrain any likely breach of covenant in the future. So it is very much a discretionary decision, but the court has to have regard to both the individual facts of the case as circumscribed by established principle. In general, the principle is that relief should be granted if the breach can be remedied and costs are paid, because the forfeiture clause is security for performance of the covenant. Here, in looking at the facts, the judge said that the nature and importance of the breach of covenant was a key factor, because construction of the zoo building was a fundamental basis on which the lease had been granted. She queried the ability on the evidence of the tenant to be able to build the zoo building, and indeed there was a long-standing breach because funding had simply not been able to be put in place over a very lengthy period. And so in summary, she decided that there was no real likelihood of the tenant building the zoo if it was ordered as a condition of relief, and she refused the application to grant relief. So what are the takeaways from this case? What should you remember after this evening and after I finish speaking, if anything? Well, first of all, the obvious benefit in the light of this decision of a covenant to remedy for landlords, because it does give the landlord a second bite at the forfeiture cherry, as it were, notwithstanding the fact that there has been a waiver. However, I would say that whether one could include a clause like this in a lease with a well-advised tenant would perhaps be another matter. Secondly, there is the interaction between waiver and the law of agency. It's always worth thinking about the basis on which the agent has been instructed. If you've got a case where rent has been accepted, don't just think, oh, rent's been accepted, there must have been a waiver. Look a bit more deeply, because it might be that it's possible to argue that the agent only carries out the treasury function, not the full management function. Thirdly, the case put forward a test for waiver by delayed return of rent, namely that there needs to be an objective assessment of the landlord's conduct and the effect that that might reasonably have produced on the tenant. And finally, the possibility of excluding the doctrine of waiver, contracting out a waiver, was tantalizingly dangled in front of us, but not decided. But certainly, as far as the judge was concerned, it was a case of why not. It could well be possible with an appropriate clause to exclude waiver. As a final footnote, you might be interested to know that permission to appeal was granted in this case in relation to interpretation of the covenant to remedy, waiver by returning rent to the wrong account, as I say, that was done in relation to one of the payments, and the refusal of relief, but the appeal has not been pursued. So that concludes my presentation. Thank you very much for listening, and I'll hand over to Jamie Walker-Howarth. Are you going to apply it to yourself?